the for-profit institution marketplace 401k plans have always had to adhere to these. They were extensions of ERISA, which was enacted in 1974, and as contributory programs, which have been around in the non-for-profit space since the 1950s, it really wasn't until the 1980s when the 401k or for-profit institutions began to kind of expand in a significant way employee deferral programs like defined contribution 401k programs. So ERISA always applied to the for-profit market. There's a long history of duties and responsibilities associated with that. But until 2009, three particular areas, government plans, church plans, and non-for-profit institutions were exempt from ERISA. And what happened in 2007 was the exemption for non-for-profits was essentially taken away, which then required that you have a named fiduciary, you have a plan document, and then you have compliance and regulatory filings. So again, it's a reasonably new requirement for non-for-profit institutions that they have to now take a different approach than they had done in the past. I think you'll find record keepers in general responding with different types of programs that help it make it a little bit easier for plan sponsors to execute those duties. But I think one of the biggest trends we've certainly seen at TIAA-CREF, as Mina suggested, was institutions starting to reach out to experts in the field to seek some assistance to make sure that they're not only compliant but meeting the fiduciary standards. So with that being said, I'm going to first turn it over to CapTrust, who's going to talk about 5 or 10 minutes in terms of some of the things they're seeing from their clients. Then we'll move on to Carroll Consulting and CBIZ, where our hope is that we leave ample time at the end for Q&A. We find that most of the time the greatest learning that comes from these programs is through the Q&A section. So without further ado, I will turn it over to CapTrust.
Hello, can you hear me?
We can hear you.
Okay, great, thanks. This is Wyatt Keys. Good morning to you. Glad to be here. I'm a retirement plan advisor with CapTrust, and I work specifically in the not-for-profit market with plans much like those of you on the line have, which I love, and we're very glad to be spending some time with you today. Joining me on this call is Scott Matheson, sitting here beside me. He runs our defined contribution practice at CapTrust, and you'll be hearing from Scott as well in the presentation in just a few minutes. And our agenda over the next several minutes is to spend just a minute or two with an introduction of who we are, what our services are, just to give you a feel, a broad feel, for how we help schools deal with some of the difficult issues that Jeff just spoke of. And then more importantly, more for the heart of the presentation, we've picked some things we hope will be useful for you. We think they may be valuable as you consider your specific retirement plan and what the future holds for that. And as an introduction to CapTrust, we were founded 28 years ago with the idea, very simple idea, of helping plan sponsors improve their retirement plans. And that still remains our goal today. And it always has an eye towards improving the financial well-being at retirement for your faculty and staff. We're based out of Raleigh, North Carolina. We have 25 offices across the country, a couple up your way, one in Bethlehem and one in Doylestown. And we have clients in all 50 states, so we're a national presence. We currently have approximately $176 billion in assets under advisement in our plans, and that covers about 2,100 plans, and specifically in the not-for-profit 403B market, we have about $37 billion under management across approximately 250 plans. And one point I would make there is that if we sort of look at our client list, I make the point that we do run the full gamut of large, medium, and small plans. While we work with some of the largest out there, we have many more of the smaller schools. Locally, I always say that I'm running around to their gyms chasing my 9th and 11th grade sons at local schools such as Ravenscroft, St. Mary's School, and Cary Academy. So I think our clients like the fact that we sort of cross-pollinate good ideas from that broad range, and we're certainly aware that there's a broad range and a different range of personnel resources, budget, and goals of the plans as they vary. So we very much try to specifically help you where you live, so to speak, and listen to your situation. And to give you a little insight into the kinds of services we provide, we often use the chart that you see in front of you. It shows a spectrum of fiduciary services. This is often a starting point for a conversation when someone says, okay, we've been doing it ourselves. We'd like to take a look at what's available in the marketplace. To the left is a sort of a simple, inexpensive sort of fiduciary in a box, we call it, list service or subscription service. To the far right is full service advisory consulting. And in the middle is a newer service for us. We call it direct fiduciary, and it's sort of a tweener between those two. So in a broad sense, CapTrust offers the middle box and the far right box as we talk through with folks the different issues using this chart. So we developed a new streamlined fiduciary service, the one in the center that we call direct fiduciary. The basic idea is that we take off your plate the heavy lifting of choosing an all-star investment lineup from the broad universe and monitoring that so that your faculty have in front of them the best choices. And we also replace and monitor those investments as necessary. But it's also a low-cost approach at about 25% the cost of our full-service offerings. Much of that savings comes from a streamlined delivery, saving travel costs. We use means like this webinar to communicate with our clients. And one last point also about this service, it's only for TIA clients who are using or moving to the open architecture or the more modern or RC platform as they call it. So we can always talk offline about more of the details, and the purpose is not to go over in this conversation all of those, but just to give a broad overview, show an example of how the marketplace is adapting to the situations that Jeff talked about, the winds of change, as I often call them. And the last thing about us, I would say, is that if you don't take away anything else, please know that we would welcome and invite a conversation with any of you, no matter where you are on the spectrum. We love that. We do that all the time. We try to keep it in plain English. In my case, it's plain English with the Southern accent, as you can tell. But at any rate, we would love to hear from you should you have any interest at any time. And now to share some of the things we've learned that we hope will be of interest to you, I'll turn it over to Scott.
All right, thanks, Watt. So I run what is called the defined contribution business for CapTrust. So it is not just inclusive of 403B plans like many of you have, as we know, but also our corporate plans. And as Jeff talked about at the outset of this call, really what the requirements that have been on plan sponsors have been on the corporate plan sponsors for years and years and years. It's only a very recent phenomena that it's actually something that you guys are dealing with, and we get that. So before we launch in, maybe just level setting really quickly, some of this is revisiting what Jeff just talked about. What have we heard? What do we know? We know that most of you have ERISA fiduciary responsibilities, and we say most because we do recognize that there's a contingent of membership that is using the church-based exemption from ERISA. That said, we have many of those types of clients that have engaged us because they choose to utilize best practices that ERISA plans do use. Unique legacy 403B structures certainly pose challenges. What do I mean there? I mean that things like individually owned annuity contracts present complexities for you in terms of fiduciary work that you may do. You may be limited to communication when something goes awry with an investment option instead of taking action that is so easy when you have institutionally owned types of platforms and annuity contracts in the 403B space. You, of course, have constrained resources. I'm preaching to the choir there. I know that your time is limited, your people, desire to have more people on this is limited, and of course money is limited. We talked to many of these clients that Watt was referencing earlier, and we know that the business officers we're dealing with on this plan, that it's a small piece of everything that they have going on, and the day we may have talked to them, maybe the day that they were out in the parking lot making sure that the buses were running on time and the parking lots were plowed if it was snowing. We would argue that now is the time. The time has candidly been since 2009, but the winds of change that Watt referenced earlier have been blowing into this end of the market. It, of course, started with the larger plans who had the capacity, both in terms of resources they could devote, people, as well as money to be able to pay for professionals, outside professionals like us, which is where we built our kind of understanding and heritage inside of the 403B market, but it has now moved into squarely the K through 12s and other institutions of your size. That said, we know change is hard, so what we thought we'd do with the balance of our time here is talk about some of the learnings that we've had and things that we think are real truisms as it relates to navigating this change, such that irrespective of hiring us, hiring CBiz, hiring Carroll Consultant, hiring somebody else altogether, or just doing it yourself, we hope that you can take away from this a couple of lessons. And let's start with first, there's a great book out there that we've enjoyed. It's called Who Moved My Cheese? And it's about this concept of change and the difficulty associated with change, and nobody likes change. We don't like change. People are, by their very nature, inert beings. You can see this type of bias really displayed in terms of your own participants inside of your 403B plans when they make selections, or if they were to be defaulted into some selection inside of the lineup, they wouldn't change. They don't change. So change is hard. We know that, and we've learned that when we do actually affect change, there needs to be a reason. So when we change for a reason. We also need to understand why we're changing and why we would change now. We would argue that things like changing demographics inside of plans are driving this change, be that the desire for open architecture, be that the fact that you've got aging populations, you've got a competitive environment for students, which requires investments in program development, capital expenditures, evolving business models. All of that are in front of you. The regulatory change we've already beat to death. We understand that that's obviously upon us. And then, frankly, the provider evolution has happened. And it's not just a TIA-CREF phenomenon where we tend to see most of our 403B plans, but if you're with any of the providers in the 403B space, they have done a nice job of evolving to give you all as plan sponsors, as fiduciaries, options in terms of how you execute on your fiduciary duties. That's the good news. We would tell you that another one of those kind of truisms is this is about change management, and one of the principles of change management is that everybody must be in to succeed. In other words, they got to be on board. We've got to achieve buy-in and agreement at an organizational level to make change successful, to make it not only happen but also stick. Ultimately, we think in this case it requires a real fundamental shift in the mindset. Well, what are we talking about there? We're talking about your mindset shifting from what we would call plan facilitator, meaning that you, hey, here's a plan, we've offered a plan, we've got people there dedicated to processing employee contributions, administering salary deferrals, they're coordinating with vendors to the extent that that's necessary. You're shifting your mindset and you're shifting your behavior from that to that of a plan fiduciary. And obviously the scope of what's involved for you as a plan fiduciary extends beyond just the bullets we've captured on this page, but at its essence and the complexity associated with it, we would tell you that people get befuddled when it comes to the how do we select the investments? Okay, we've got them in, now how do we monitor them? What if something goes wrong? How do we replace them? And then, of course, we've got to make sure that we document the process. The ERISA and the way that the Department of Labor interprets and enforces ERISA, they would really, and if you go back and read anything from them, you would understand that it is about process. It's about prudence in terms of investment decision making, but it's about process as it relates to the implementation of the law set and the regulatory interpretation. That's hard to do. It's hard to do when you're, as we talked about earlier, balancing all the other duties that are upon you in your capacity. But it's also hard to do because the environment, the legacy environment, if you will, where assets have been, plan assets and participant investments have been really to date, has not helped you in terms of facilitating your ability to do that, to select investments, monitor investments, and replace investments as you should be doing as a fiduciary. And kind of closing on that point, and just another kind of tip of something that Tip's shared, something that we've learned. We found that when we talk through this with our clients, it really is about starting with the end in mind, and that's really important. The way of how we contextualize this with our clients as we sit down with them and we say, look, let's talk about where we want this plan to be in 5 years. What that does is effectively gives us answers to a question, and we can then sketch out what that roadmap is, the roadmap that we think leads to a successful transition to that 5-year plan over time. And you can start chopping out and parsing up the step-by-step. How do we get there? We put a couple of examples here. They're frankly numerous in terms of what those examples could be, but maybe you do have a desire to go from an individually controlled platform, in other words, with many of the popular providers, TIAA-CREF and others, you may be in a situation where what's offered today and what our plan assets today are actually controlled by individually contracted annuities, meaning that you don't, as the plan sponsor, actually have control over those assets. Your individuals do, and you're expected to apply these fiduciary standards to them. You can fix that on a prospective basis, and you can go to an institutionally controlled environment or institutionally controlled annuity type of environment. That certainly is an option for you. We would argue that's not a 5-year thing for you to do, but it could be where you want the plan to be at the kind of next iteration of the plan. You need to know that, acknowledge that, and then you can start chopping up what does that take to get there. Well, it means that now I move from a limited platform of options to, generally speaking, the world is my oyster in terms of investments, I'd say. How do I pick those investments? Well, I got to choose from not 10 now. I've got to choose from 15,000, let's just say. Those are the kind of things that you start to think through. Maybe you want to go from what I called here an opt-in plan to an opt-out plan. In other words, you want to tweak your plan design such that you're defaulting people into the plan when they become eligible unless they opt out, instead of waiting for somebody to fill out the enrollment forms and make their way into your plan. Maybe you're doing this to have provide better benefits and better savings rates for your employees such that they're better prepared for retirement. Maybe there's a number of other reasons you're doing it for workforce management purposes. But regardless, those are the types of things we're talking about, sitting down, coming up with a plan, starting with the end in mind and working backwards to get there. I'm going to close on that, and hopefully what we've done is just share with you a couple of, as we like to call them, nuggets of wisdom and items that you can use regardless of who you end up hiring, if anyone, to help you navigate this, what I know is at times a daunting task in front of you. And as Watt said, we certainly appreciate the opportunity to talk to you and are always happy to have a conversation. So thanks, Colleen. I'll hand it back to you.
Okay. If anyone has any questions, you can type them in the question box. And if not, then we can move to the next presenter. Okay. So I'll turn it over to Marcy Carroll from Carroll Consultants.
I'm sorry.
Marcy?
Can everyone hear us?
We can hear you.
Okay. I know a lot of people do tend to mute me out, but for this purpose, hopefully you can hear me. Well, thank you, Mina, Emily, Colleen, and the Pays BOA Retirement Committee for this great opportunity to talk to the schools about fiduciary duties. Such an interesting topic. I'm Marcy Carroll. I'm here with Tom Gidgoud. We're from Carroll Consultants. And just a little bit about our firm. We have two arms to our company under one umbrella. We have a registered investment advisory firm, and then we're also an administrative services firm where we help with documents and testing and all of those different areas of the plan. We've been around a really long time, although Tom and I haven't been around that long. The firm itself has been around for over 60 years with special emphasis on retirement planning and in particular schools. We love working with the schools. We're an independent firm. These are some of the providers that we work with. There's TI, CREF, and a few others. We are independent. A little bit about us, a little bit more about us. We're local, so many of you listening in, hopefully we've met you in person, and we have personalized service. We go on campuses, and our local presence, we hope, makes a big difference. Schools are our niche. We absolutely love working with schools, work with hundreds of them, and we really try to focus on fiduciary training. So as you'll see in the next few slides, we tried to simplify some of the fiduciary duties out there, which can be quite complicated. So hopefully we can explore, Tom can explain them in a relatively simple manner. So now I'm going to turn it over to Tom.
Okay, Marcy, thank you very much. My name is Tom Gittiaud. I'm the Chief Investment Advisor for Carroll Consultants Advisors. I'm a CPA, I have a master's in tax. I've also served as a expert witness in federal court litigation. So our goal today is to easily explain to you what are your fiduciary responsibilities in administering a 403B plan. So to start off, in hiring an investment advisor, there are two types of investment advisors connected with a qualified retirement plan. So we'd like to just explain the differences between each of them. So one is called a 321 advisor. The 321 is just a section of the Internal Revenue Code. And under hiring a 321 advisor, this is where the investment advisor will make investment recommendations, specifically which funds to offer in your plan. However, under 321, the plan sponsor or the retirement committee, who are fiduciaries, they have the ultimate decision making authority to implement these funds. So what you have in a 321 is a shared fiduciary liability, shared between the investment advisor and the fiduciaries, meaning the plan sponsor or the retirement committee. Under a 338 advisor, the investment advisor still makes investment recommendations for which funds to offer in the plan. However, here, the investment advisor has the ultimate decision-making authority in offering these funds in the plan. And so the investment advisor has full fiduciary liability when it comes to the investments that are offered in the plan. So simply this, that's the big difference, okay, between a 321 and a 338 advisor. So now let's just ask, hey, who is a fiduciary with respect to our 403B retirement plan? So ERISA has defined a fiduciary as any person or committee that has discretionary authority or responsibility in the administration of the plan. Anyone who exercises discretionary authority or control with respect to plan assets, or anyone who renders investment advice as to plan assets for a fee. So let's just look at some examples of who would be a fiduciary. So if you have a clerical person, let's say, that is submitting payroll deferrals to the record keeper, okay, they are clearly not a fiduciary, all right? That is more of an administrative function. However, if you have, say, a business manager or individuals or committees, retirement plan committees, that make decisions such as to the plan provisions, okay, eligibility, match amounts, hiring investment advisors, anything to do with plan assets, they are clearly a fiduciary. And investment advisors to the plan are always a fiduciary. So that's at least who a fiduciary is as we get into what are the duties of fiduciaries. So we get this question a lot because there are church plans out there. So So if a school is a church plan and not subject to ERISA, which church plans are not, do we need to worry about fiduciary responsibilities? So under ERISA, the answer is no, because you're not a fiduciary, okay? However, it's important to note that every state has laws that have similar concepts, okay, under fiduciary or trust rules. And they do place a responsibility on the school, the employer sponsor of the plan, even if you're a church plan. So the best way to satisfy those duties under a state level would be to follow what the best practices are under ERISA. And not to scare anybody out there, but there are court cases out there that involve church plans. So that's what you want to do from a best practice standpoint if you are in fact a church plan. Okay, so now starting with a retirement committee, one of the most important functions of the retirement committee is for selecting, monitoring, and retention of the investment fund offerings. So obviously you can farm that out and hire an investment advisor, to do that. So we provide fiduciary education to committees, and just to explain to them, what are all these duties? So in the handouts, or in the attachments I should say, there's a very short fiduciary checklist that you can refer to. It's about 3.5 pages that clearly delineates what all these responsibilities are. So you want to be able to check yes that you fulfill them, or at least hire someone to fulfill them for you. And then we've helped with forming committee charters, and it just describes the authority and the duties of the committee. This way, everybody knows who is a fiduciary, who's responsible, and what those duties are. So now, clearly, okay, there's a requirement that you document the process of fulfilling these fiduciary duties. And so the best way to do this is, first of all, you need to refer to your investment policy statement, which will give you the roadmap for selecting the funds, retaining them, or possibly replacing them. And how did your retirement committee go about reviewing and monitoring these funds? So most of the time, your advisor will provide you with a very well-documented due diligence investment review report, and then you need to keep minutes of the meeting, okay? And we'll see later in the slides that you may be called upon, hopefully not, okay, to be able to substantiate that you monitored your funds and you did this on an ongoing basis. So a little bit about the investment policy statement. So this is the roadmap for your fiduciary investment decisions. And again, you can hire this out to an investment advisor, but you need to follow the investment policy statement. And the reason for this is because this is going to be the standard in which any investment decisions would be measured in case there's any litigation. And it's important to note that you have a duty to review your investment policy statement annually. So even though this is a small slide, to be able to select and monitor the funds is a pretty in-depth and detailed process, okay? So you have to, it's a duty under the fiduciary rules that you have to monitor these investment fund offerings, and you have to offer a broad range of investment funds. So what does that mean? So you have to offer a stable value fund, a different equity offerings, okay, fixed income funds that cover all the asset styles. And then if a fund, for whatever reason, is not passing a due diligence review, you need to be able to remove that from the fund lineup and replace that with a better fund. And then there's also a type of fund called a Qualified Default Investment Alternative Fund. That's what QDIA stands for. And you want to make sure that you have an approved QDIA fund in your lineup. And this is the type of a fund where if there's any mapping going on, or if you have participants that don't select their investment options when they enroll, or if you have automatic enrollment, if the investments go to the Qualified Default Investment Alternative Fund, you're protected from liability. And the most prudent funds on this are what's called the target date funds. So one of your other duties, okay, is you have to monitor fees. So before we talk about this, let's at least explain what are some of the fees that are associated with sponsoring 403B plans. So you have record keeper and custodian fees, okay? So what does that mean? So record keepers and custodians are entities, such as TIAA-CREF, that collects the remittances from the school, collects the employer matches, invests them into the funds that the participants select, offers a robust website, okay, does your quarterly statements, helps out with any notices that have to go out. Then you have your investment advisor. That is the firm that helps you choose the robust fund offerings to offer to plan participants. You can have TPA firms, third-party administrator firms. They would charge fees for preparing Form 5500s, doing discrimination testing, and if you have a sufficient number of plan participants, you may need a CPA plan audit. These are all the fees that can be associated with it, with the plan. Okay, so you have to benchmark these fees. So how do you make sure that these fees are reasonable? So there are a lot of comprehensive fee benchmarking databases out there, okay, to where you can compare these fees. Another way you can do this is to ask for fee quotes from any of those providers that were just listed on the prior slide. You could do an RFP, and then you can actually use these fee quotes to negotiate these fees with any other providers that are there. So now, other fees to consider. So when you offer open architecture in a qualified retirement plan, open architecture means that now you're going to be able to pick from the myriad of mutual funds out there, no matter who the record keeper and custodian is. Vanguard funds, Fidelity funds, American funds, T. Rowe Price, whatever. So in order for record keepers and custodians to be able to offer these open architecture funds, they need to be paid for being the record keeper and custodian. So they have what's called a required revenue to run the plan. And that's going to depend on the plan metrics, size of the plan, average account balance, number of participants, etc. So that's number one. Number two, depending on the share class that you pick, some of the fund operating expense in those share classes from the funds have embedded in them what's called revenue share of plan service fee, and they're amounts that the fund company does not keep but remits back to the record keeper to be able to pay them for that required revenue. And sometimes this could cause a RAP fee if the required revenue that they need to get is not completely satisfied by the revenue share plan service expense. So that's something else to be considered when you're moving to open architecture. So now, in summary here, so what happens if you don't do anything? Okay, well, that's not a good idea. And the reason why is that just recently, Supreme Court case Tibble versus Edison, May 18, 2015, clearly states, okay, that fiduciaries have an ongoing duty to monitor their investment funds to remove imprudent offerings. And you have to document and prove this, okay? And so it's very clear now, okay, that needs to be done. And so what can happen, the worst case scenario, you could be subject to class action lawsuits. So we hope that this short explanation kind of easily explained, what these duties are, to be able to help you be able to fulfill them so you can sleep comfortably at night.
Are there any questions? Did everybody?
There are no questions as of yet. We'll give people a few seconds if they have any last minute questions. Otherwise, we can turn it over to CBiz. Okay, I'm not seeing anything, so I'll give the presentation to Karen Roberts from CBiz. Sorry, Karen?
Yes.
Hi.
Okay, you can hear us now. Good. Hi, everyone. Karen Roberts is with me. I'm John Schubert, Vice President with CBiz Retirement Plan Services, and with me is Karen Roberts, who's a Vice President of Operations and Compliance, and Mike Casekamp, a Senior Consultant in our Maryland office. We want to thank everyone for being here today, of course, and also to thank PSBOA for hosting this discussion. Briefly, as with the other folks, give you a little bit of background about CBiz. We're a publicly held company. We specialize in helping higher ed and K-12 schools, institutions with the retirement plans. We have 100 offices throughout the country. We also happen to have an office in Plymouth Meeting, and we serve over 150 TIA and other higher ed institutional clients on the TIA platforms and other retirement plan platforms. And this represents, we're in service, we provide our services to approximately $70 billion in retirement plan assets throughout the country. Much of today's topics have already been covered kindly by Tia and by the other folks earlier, so we are going to just be briefly touching on 403B compliance update, meeting your fiduciary services, and of course, best practices is something we want to spend a few minutes focusing on. As Jeff summarized, the Pension Protection Act was, the regulations were finalized in 2007, and on this page, really, the most important point here is the bullet point where there is certainly more focus on proactive fiduciary duties, and proactive is certainly the operative word. So what does that mean to each of you? To meet our fiduciary duties, the ERISA standard, and of course, folks have already addressed church plans and non-ERISA plans that mirror ERISA standards, but the ERISA duty and the foundation, the underpinning of all of your ERISA responsibilities is that we are here all to act solely on behalf of the participants in the plan. And yes, as the folks from Carroll just mentioned, it never hurts to have that requirement, even though that requirement existed since 1974, the ERISA requirement. It's important to see that has been underscored and affirmed by the Supreme Court recently. And what they really also said in that ruling, not only that it was a continual requirement, but it really meant that folks who thought, aha, I've made some decisions, I had good information when I made the decision, I'm finished with my responsibility. The Supreme Court served as a wake-up call to let everybody know that responsibility is certainly, and that liability is certainly continual and ongoing. So bullet point 4, what might a comprehensive process for ongoing fiduciary practices look like? We recommend having a formal committee in place at each of your schools. That might be 5 to 7 numbers. Clearly an odd number and for voting is sometimes constructive, but 3 to 5 folks on a committee at each of your schools would be perfectly appropriate. We recommend meeting as a retirement committee at least 2 times a year. 2 times is fine, 4 times is great, but there's no ERISA requirement or mandate that you meet more than 2 times. Periodic and routine and ongoing oversight is truly the requirement. And we, as other folks on the call today have mentioned, we really highly recommend having a formalized, documented fiduciary process in place, and for people on your committee at your schools to participate in fiduciary training to enhance your expertise, not trying to make you experts as fiduciaries, but really expertise in enhance the level of understanding you have as you execute your fiduciary responsibilities at each of your schools. And as you can see here, we pride ourselves on providing those formalized processes to each of our clients' schools. On this page, this graphic image really also serves to underscore what's being said today. And one key benefit of having a specific process and a set of processes in place is that a few minutes ago you heard a discussion about who is a fiduciary. Well, very likely the board of trustees for your school and for your plan can be very readily deemed fiduciaries depending on how decisions take place in your board meetings. If decisions take place during your board meetings that could and might have a decided impact on your plan, or even indirectly have an impact on your plan, your board of trustees might be deemed fiduciaries. And most of them right now probably don't know that they might be. So a process in place, and more specifically a set of documentation around those processes in place, can really serve in a very constructive fashion to insulate your board of trustees and each of the folks that have any responsibility related to your retirement plan. What might those documents look like? We would advocate, and this is what we provide to all of our clients, we would always provide a board resolution specific to your school, and a document that is an appointment to the retirement plan committee, acceptance of that appointment to the retirement plan committee. We would draft retirement plan committee charters. You heard a lot of discussion about investment policy statement. Clearly, an investment policy statement would be fundamental to your documentation, and yes, committee meeting minutes as well. Other best practices, again, you heard it earlier, you would review your plan on an annual basis. Now, there's a set of ongoing activities that take place with regard to comprehensive fiduciary retirement plan oversight. Some of these are quarterly, some of these are annual. Investment performance reviews, for example, would be provided on a quarterly basis. We provide our clients with quarterly soft reports and hard reports if they wanted hard copy reports. And also, because each of you have activities related to your school's retirement plan, how do you make this task easier? And one of our presenters mentioned the fact that you're trying to have make sense of 15,000 potential investments in an open architecture environment, for example. Yes, as an investment advisor, as an investment fiduciary, we're looking at shorter lists. We're employing screens and filters to determine which funds are the best funds, which ones go on a watch list. But we also do provide recommended shorter select list portfolios because, again, you folks have day jobs, and it's very difficult to wade through so many fund choices. And so the task of making that easier in the performance reports and executive summaries in performance reports and ongoing investment reports is something that we're very sensitive to on behalf of our higher ed and K-12 institutions. Again, you heard a few minutes ago about having an investment policy statement and reviewing it annually. Yes, this is an absolute requirement because the investment industry is dynamic. Regulations change, and even the best practices we talk about change. So having your investment policy reviewed on an annual basis is absolutely fundamental to proactive fiduciary compliance. At CBIZ, we do also assist our clients with the transition to the new open architecture platform, but everything we're describing is also applied to the existing, we can call it the legacy or old contract individual annuity platform. You've heard about benchmarking your plan periodically. Yes, that's also a requirement to make sure that your plan services are competitive and within the industry standards. There's no requirement to benchmark your costs annually. Periodically is sufficient, because the cost landscape the fee landscape doesn't necessarily change every year. If you were to experience any changes in your fees by any of your services providers, that might be a time to benchmark your fees. You also, in terms of just a best practice, you'll want to review your actual plan provisions against your industry peers. Plan provisions might include your loan provisions. What do your loan provisions look like versus your peers? Or what do your match provisions look like versus your peers? And then even if you engage a provider like any of the three of us on the call today for fiduciary services, whether it's 321 or 338 services, yes, those services certainly mitigate your risk and your liability to an extent, but you can never abdicate completely your fiduciary responsibilities, even when you're hiring an independent investment advisor. So what does that mean? What it really means is that you still have a requirement to ensure that the provider that you've hired is qualified, continues to be qualified, has the resources, in fact, that they've suggested that they have to provide those investment advisory services as a contractual fiduciary. So you have an ongoing requirement to make sure that those qualifications are in place. Worth noting is your investment advisor independently audited, such as through CFIX, an independent certification entity? Does your provider have ERISA counsel in place? Does your provider have CPAs and CFAs on staff and QPAs on staff? So these are the type of things that you'll want to know, and the questions that you'll continually ask, and should be part of a checklist of due diligence. We do provide to our clients an annual consultant review due diligence checklist just to keep you apprised, and we also provide to our clients something we call Success Tracker, because if you have the processes in place and the best practices in place that the three firms on the call today have been describing, then you'll want to certainly memorialize and have an ongoing living track record, document record of those services. So we do, on behalf of our clients, provide documentation about the ongoing, continual fiduciary duties that are provided and implemented on your behalf, because should the DOL walk in your office, that's along with investment policy and a few other documents, this is something they're going to ask you about. Benchmarking, we just have this page on to let you know that when we do benchmark our clients in our higher ed institutions, that we're doing so with a great focus on fees and expenses within the industry landscape. And then finally today, any school, of course, can go it alone. You don't need to use a consortium model. However, at the risk of stating the obvious, a membership in a consortium does really provide very, very compelling cost efficiencies and scale. And we're a lot like our clients. We really love our school clients because typically they're very risk adverse and they're very process oriented, which is a lot like we are. So the consortium model really lends itself to delivering risk mitigation services and process-oriented services in a comprehensive way, but in a highly highly reduced cost environment. And one of our presenters earlier mentioned that in today's 403B world, the fiduciary due diligence and the fiduciary governance procedures that firms like us are providing are much like the corporate world, and that's true. We have Fortune 500 clients, and we're here to say that the fiduciary services provided in a consortium model very, very much mirror the extent and comprehensive aspect and comprehensive nature of the Fortune 500 type fiduciary services that we provide. So I want to thank everybody for being here today and sharing your morning with us.
Thank you.
Okay, it doesn't look like we have any questions. If anyone has any for CBIZ, they can type them in now. And doesn't look like we are getting any. So I can, oh, maybe here's one. Oh, one sec. Jeff would like to say something. Go ahead, Jeff.
Great, Karen, can you hear me?
Yes.
Ah, my God, the advancements we're making in technology. I'm getting there. You know, you get into your 50s, you start, you know, you're on the backside of the technology curve. Just a couple things my folks are kind of thinking about some of the questions they had, and I think it's just some things that I was going to talk about at the beginning, but I wanted to get right to our panelists pretty quickly. But the two things I often work with plan sponsors on, and I know most consultants kind of get on this path as well, I think the folks at Carroll mentioned a little bit, is there are two reasonably significant, I call them get-out-of-jail-free cards that the Department of Labor provides plan fiduciaries. I happen to be around because I'm an old man for both the enactments of these from the Department of Labor. The first one was in I believe it was 1990. As 401k plans were gaining in popularity, plan sponsors went to the Department of Labor and said, look, we think these programs are very beneficial to our participants, and we'd like to expand the use of them. However, coming off the heels of significant litigation in the defined benefit marketplace, we don't want to create a liability to the company somewhere down the road, 20, 30 years from now, that puts us in a little bit of a jeopardy. So would you, as the Department of Labor, kind of the rulemaking body of Congress for benefit programs, could you please provide us with some guidance here as it relates to expanding these programs? And the Department of Labor did, and they enacted something called 404C. It's often talked about in our world quite a bit because it is the fiduciary get-out-of-jail-free card. It's rather vague, though. It requires that plan sponsors really adhere to three basic principles. It's more detailed than that, and the three principles are: you need to offer three different and distinct choices to your faculty or to your participants, but it does not say what the three different and distinct is. In fact, when they made that ruling, the stable value industry that I was a part of at the time was asking for a safe harbor provision, but it was not granted. And it said that you need to offer choice, and three different and distinct is how they clarified that. It also asks that you provide ample information in order for participants to make informed investment elections. Most organizations like TIAA-CREF or others will assist the educational kind of component of that. And then the third component of it was that you allow participants to transfer their account balances commensurate with the risk of the investment offering that's there. And most of the programs that you have at least daily transferability of account balances that are in there. But the specific thing about 404C, or the unique thing, is that it only covered plan fiduciaries as it related to decisions that were made by participants. As time progressed and we approached kind of the early part of the 2000s, we had a very long bull market. These defined contribution plans expanded quite significantly in the marketplace. But the participation rates on elective plans tended to be about 2/3. We were only getting about 2/3 of eligible participants to actually participate, no matter what the plan sponsor did, what the vendor did, what the record keeper did, what the investment managers did. We just could not get that last third. And the industry as a whole started moving in the direction of suggesting that we automatically enroll participants in the program as soon as they start employment and opt out if they did not want to participate. The challenge with that is that 404C did not provide that election, because if you were automatically enrolled, there was a high probability that the participant did not make the investment election. So we went back to the Department of Labor and said, can you help us out again? We'd like to automatically enroll. We think it's beneficial to our participants. We think it's beneficial to our society that folks participate in their retirement program. However, 404C does not protect us, and we're not going to kind of invoke a particular approach to our benefit program if we don't feel protected. And that's where Tom had alluded to earlier, the QDIA came out of PPA. And what it said is if you adhere to certain principles, much like 404C, and you follow these principles, then we will give you a second get-out-of-jail-free card. And as Tom indicated, there's 3 categories that you can pick as a plan sponsor. It's a target date fund, a managed account fund, and a balanced fund, so long as the balanced fund represents the population of your participant base. So I just wanted to kind of give, I know it's a little bit more detailed than probably many wanted to hear, but I did want to kind of mention some of those get-out-of-jail-free cards that the Department of Labor has put out there in terms of safe harbor provisions. So thanks for the time. Hopefully that bought you a little bit of time to ask some questions too. So fire away, folks.
We actually have one question that came in. She'd like each firm to make clear whether they are a 321 advisor or 338 advisor. I'll just go ahead. Karen's already unmuted, and I'll unmute the rest too, so they can all answer.
This is John at CBiz. Our services package that we'll provide contemplates 321 services. We have 338 services, but the offering that we'll send you and the scope of services and the costs related to that have to do with 321 co-fiduciary services.
Okay.
On both platforms, by the way, folks.
Okay.
So this is Tom Gidgoud from Carroll Consultants. Our advisory firm can serve as both 321 advisor and 338 advisor, and we have current advisory clients that have hired us to do both. So we can do either one.
On both platforms.
Yeah, on both platforms.
And this is Scott Matheson from CapTrust, and from our perspective, we too, just like the other two, will serve in a 321 capacity. For clients, the pricing that was mentioned at the outset and the offering that we're talking about here is designed to be 338, though, or discretionary in its approach. And if you think about the requirement for us to be discretionary, we need to be able to actually affect change, which means that our fiduciary role, the 338 role, is actually limited to institutionally owned contracts, so that we're clear on that. We help our clients navigate the fiduciary duties that continue to exist on what we call legacy, individually owned assets and contracts. But for our role, just as you might imagine, for us to actually affect change and take discretion, we need to be able to do that, and that's limited by some of those complexities we talked about earlier, but hope that answers it.
Okay. It doesn't look like we have any more questions as of now. Mina?
Helene, I do want people to understand the idea of moving over from legacy to the new institutional contracts, and this is really related specifically to TIAA and not for those who have other plans. It is a significant amount of work, and we have not had a meeting to discuss, the steps and all those things, but this isn't to scare anybody away either. I mean, I just want people to be encouraged to move forward with what they think is the best way for them to do this, and that you may want to get your own ERISA attorney involved about, what level of, or whether you can fulfill your fiduciary or co-fiduciary responsibilities in both platforms or not. And I think it's important that we all make our own individual decisions on that piece. I think that the 3 consultants that we have may have different perspectives on that and provide services at different levels. And I will also say that while one firm may only be offering us a certain pricing based off of one set of services versus another, I believe that all of the firms can provide the services. It would just be at different pricing points. And so I just want to be clear on that. Is that correct, CBiz, CapTrust, Carol?
Yes.
That's correct.
Yes, Mina.
Okay, so I wanted to make sure people understood that. And The three firms have received or will be receiving from Emily and or Colleen a list of people that are on this call and perhaps others in Pays Boa, where they will send to you directly their pricing schedule that we have worked out with them for the Pays Boa membership. So that'll come after this conversation. And the presentations themselves will be sitting on, I believe, Colleen, please correct me if I'm wrong, but on the Pays Boa website, correct?
Yes, so all the materials from the presentation will be in the library, and this is also being recorded, so I'll have the recording in there after the presentation as well.
Great. And if there are no other questions, thank you very much, everyone, for your time, and to the participants and to the panelists on this call. And I really appreciate all that everybody has done, including Pays Boa, Colleen, and Emily Miller. Thank you so much.
Thank you very much.
Thank you. Thanks for having us.
Thanks.
Bye-bye.
Thank you.